Yes, the complaining witness or the prosecuting attorney was notified. And then is this the complaining witness that's in the courtroom now?
No, that's her attorney. Or at least so.
Okay.
Good morning, Your Honor.
Okay, thank you. Okay. All right, so we are going on the record in the matter of the state of Michigan versus Shadid Howard Randolph 23302. And appearance for the people, please.
Good morning, Your Honor. Please have the people P2114.
Thank you. And counsel?
Good morning, Your Honor. Mr. Shanky is going to be my client who stands to my immediate right.
Thank you. And Mr. Howard Randolph, your name, please.
Shadid Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. And I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, whether it be the prosecutor, your attorney, any witness testimony, or the court, you will be held in contempt of court. I just want to make sure you understand that. Do you understand that?
Can you repeat it again? Did I do something wrong? You said I did something wrong.
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. You had a disastrous record.
Stop.
We had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt of court. Do you understand that?
Yes.
And Your Honor, my client understands that I will be speaking for him today, pretty much for the majority of this, for this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. No, you cannot. You just were told no interruptions. Just stand there quietly. I will do all the talking. Just interrupted me, and that's something you said you weren't going to do. I'll do it. We're ready.
Okay, Ms. Ozera, would you like to address the court? If you can step forward, please.
Mr. Honor, I am representing Ms. Duff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during these proceedings, which would violate the no contact. And I believe that that will continue to happen. The decorum of Mr. Howard Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
And when you indicate that Mr. Randolph has been addressing Ms. Duff directly, is that during Mr. Randolph's turn to ask questions? Is he representing himself?
He is representing himself. It has not been with regard to any direct examination of Ms. Duff. He has not chosen to, at this point thus far, to question Ms. Duff personally or cross-examine her. This has been in his statements to the court, which then devolved into him directly addressing Ms. Duff.
And Your Honor, we're going to be in the process of getting the transcripts of that particular hearing this week. We don't know the specifics. If the court were not
At this point, the defense makes one final request before the judge rules. The attorney asks if Howard Randolph can briefly retrieve his newly financed vehicle before reporting to custody, explaining that no one else is available to move it and that having it towed would only make his situation worse. Despite acknowledging the concern, the judge refuses to delay custody, citing serious safety and compliance issues. Instead, she offers a practical solution. Randolph can leave his car keys with the police department so a family member or friend can pick up the vehicle later. The decision makes it clear that convenience will not outweigh the court's responsibility to enforce its orders.
on any further bond conditions, that he be able to report into custody after taking his car in.
Okay, and I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick up the key later with the vehicle. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court's orders. So the court is indicating 10,000, 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note that with what your vehicle is so that it's not towed and that somebody can pick it up within the next 24 hours or
Can I
so.
say something for the courts?
That's up to your attorney.
Well, that's up to me. I got my own mouthpiece. You done already do what you gonna do, bro.
Sir,
Okay.
let me just be very clear.
Mhm.
Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not.
Allegations.
Because-
So.
because-
Continue commission. needs to
You're
be-
interrupting me
Okay, go ahead.
because something you say could be used against you.
Mm-hmm,
So that is why I indicated if your attorney
mm-hmm.
suggests that you speak.
I'm just saying the Michigan Tenure Commission needs to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly intending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate "15 days jail for contempt." The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order, nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to
speak my mind.
not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay, but hey, you filed a false police report, you let it get in your courtroom, so did the prosecutor and the tenure
Sir.
commission will hear about it, and it's already, you got
Sir.
a grievance on you already right
Sir,
now. And
you
another one
may
is
file anything that you
June the
choose.
first, hey, listen,
You
this
may
domestic violence.
Stop interrupting.
You're gonna
Stop
get sued.
interrupting.
I guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the
Rio, I love you,
17th.
baby.
Even after being sentenced for criminal contempt, Randolph continues arguing with the court instead of accepting the judge's decision. As deputies prepare to remove him, he keeps insisting the case is based on false accusations and attempts to address the alleged victim despite repeated warnings. His continued interruptions only reinforce the judge's earlier ruling that he was unwilling to follow courtroom rules or respect the court's authority. The hearing ends with Randolph being escorted out, serving as a reminder that challenging the court's authority through repeated disruptions can quickly turn an already difficult legal situation into an even more serious one.